Court is calling 2025 CR 007409. State
From the
versus
very first call of the docket, you can already feel the tension. Judge Boyd's courtroom isn't just a stage for the law, it's a battleground for second chances, broken promises, and the harsh reality of repeat offenders. Patrick. Thomas sits before her, a man with multiple theft convictions, facing yet another felony. The range? 2 years in state jail and a hefty fine. But here's the twist. This hearing isn't only about punishment. It's about whether a judge believes a defendant is truly ready to change or doomed to repeat the same mistakes. And Boyd makes sure Thomas knows the stakes.
State versus Patrick Keith Thomas. Can I have parties announced?
Jason Gary for the state, Your Honor.
James Doty for Mr. Thomas, Judge.
And are you Mr. Thomas?
Yes, ma'am.
Counsel, is there an application?
No, ma'am.
All right. Counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Thomas, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft with 2 or more previous convictions as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 180 days in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense.
Think about this for a second. By signing his plea deal, Thomas is essentially surrendering his right to fight back. No jury, no appeals, just the cold stamp of the law. Would you have the courage to do the same? Or would you roll the dice and face a jury knowing your past convictions could haunt you? That's the moral knife's edge Thomas is walking on. And Judge Boyd doesn't sugarcoat it. She reminds him that his plea bargain is fragile. One wrong move, and the deal collapses, leaving him with nothing. Ask yourself, is that justice or coercion disguised as choice?
Defense.
Yes, Judge.
State.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
Without objections, Judge.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We're ready, Judge.
Anything you wish to say on behalf of your client?
No,
What
ma'am,
you
at all.
just heard may sound routine, but it's not. Thomas's lawyer didn't even fight. No defenses raised. No pleas for leniency. Just silence and acceptance. This is what happens when the system wears people down. Sometimes the battle is lost before it even begins. Judge Boyd hands down 180 days, but the real sentence isn't just jail. It's the cycle Thomas is trapped in. Theft after theft, court after court. And the judge knows it. That's why she pauses to lecture him. Because here's the truth. The law can punish, but it can't fix what drives someone back into that chair.
No, ma'am, at all. We're obviously just asking the court to honor the agreement.
All right, the court will sentence you to 180 days in the state jail facility, give you credit for any time served, and there's to be no contact with Walmart. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so we can go off the record. Here's the thing. If you don't stop doing this, you're going to end up in and out of jail. You understand? And out of prison.
Only thing I can say, Your Honor, is stupid.
Yeah. So,
I don't have an excuse for myself.
Yeah.
It's really stupid.
well, I mean, you have to figure out why you're doing what you're doing and stop it, okay? Because otherwise, it's not going to end good. And at some point, these state jail felonies, the range of punishment becomes 2 to 20. All right?
Yes, ma'am.
So if it's a homeless issue, there are plenty of places to stay. If it's a compulsion issue, there are plenty of places you can get help. You understand?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
You're welcome.
Good luck.
Who is here on Raymond Francis Haynes?
Morning, Your Honor.
Good morning.
Does Mr. Haynes need to come forward, Your Honor?
Yes.
800. Hard to get people up here.
Oh, it is. People don't want to come. But you know, I've discovered during jury trials, people don't want to leave. Jurors want to leave, but then they don't want to leave. All right, where are we on discovery?
Judge, I think discovery is complete. I believe discovery is complete.
Yeah, that's what I was going to judge.
All right, so I need an acknowledgement of discovery before you leave. And was an offer tendered today?
No, Judge, defense counsel can explain that.
Yeah, not yet, Your Honor. We would like to have Mr. Haynes. He's 100% disabled for veteran, and we would like to have him evaluated for VTC. I guess I'm not. I think that after that, if he's eligible, then we get an offer. But that's. I think that's the route we would like to go down as of now.
All right. Bashan, do you have any idea how long it would take VTC to review him? Right. So just have a seat. They're going to call VTC and see how long this will take, and then I'll give you a date.
Thank you.
You're welcome. Who is here on Robert James Kianis? No, I have Matthew Dotson, Martinez, and Haynes. All right, Mr. Kianis, come up. All right, so in this case, where are we on discovery, counsel?
I confirm with Duffy, it appears that we have everything. We're just asking for a short recess. We can go through it all and confirm that we're not missing anything. If the court would let us come back in 2 weeks, just so we have time to make sure we aren't missing any additional discovery.
All right, Norma, if I can get a 2-week reset for discovery, please. All right, we'll bring you back on August 21st for discovery. It's to make sure that your attorney has all of the information that the state has. Do you have any questions about anything?
I would just like to raise a timely objection to the Texas being abstract subject matter jurisdiction, and I'm not waiving the right to the defect.
All right, so you're saying subject matter jurisdiction? All right, so usually when you're speaking of subject matter
Just wanna raise
jurisdiction,
the objection.
no, I hear your objection. Usually when you're speaking of subject matter jurisdiction, that's usually on the civil side. So what I can tell you about subject matter jurisdiction in this court, and I think I know what you're trying to say. So you're charged with a felony. So this court presides over felony cases. So based upon your indictment, which is a felony indictment for aggravated assault with a deadly weapon and unlawfully carrying a weapon with a felony conviction, those are all felony offenses under the penal code. So you are in the correct court. So the subject of your indictment is what the type of cases this court handles.
And I'm gonna be able to have a trial, right?
If you, I can't give you any advice, but your attorney is here to assist you. And if you want a jury trial, of course, the court will give you a jury trial. But what I usually do in the process in this court is I want to make sure that your attorney has all of the discovery, which means he has everything that the state has. And if he thinks there's something the state doesn't have that he should have, he's entitled to have that. And then once he tells me he has all his discovery, then I will set this for a plea deadline date because I require that the state tender an offer to you. You can discuss that with your attorney. If you decide not to reach an agreement with the state, then the next course will be a jury trial. All right? All right, thank you, sir. Have a good one. All right, so where is he? Come forward, please. All right, can you raise your hand? You solemnly swear and affirm all is true and correct, including your personal knowledge. All right, if you'll fill that out, and then I'll take it up. All right, Larry Morris, Matthew Luis Martinez. Just let me sign this.
Every once in a while, I sign those too.
I don't do it from a district bench, I do it from a justice of the peace.
Hey, it's still needed. All right, thank you. Have a good one. All right, court is calling 2025 CR 05084 State versus Matthew Luis Martinez. Could I have parties announced?
Ashley Jones for the state.
Tommy Ramirez representing Matthew Martinez, Your Honor, we're present and ready.
All right, and are you Matthew Martinez? I'm going to need you to speak up so I can hear, okay?
Your Honor.
And the court reporter. Counsel, have you received all of the discovery in this case and did you review it with your client?
I did, Your Honor, in my office.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the application for deferred adjudication with your attorney?
Yes, sir.
Did you understand it?
Yeah.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes.
Just one moment. Do y'all have the indictment on Martinez?
I actually have an extra copy, Your Honor.
All right, thank you. Thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with burglary of a habitation? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able, I'm sorry, is he applying for deferred adjudication as well?
He is, Your Honor.
All right, did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, we've been able to discuss it at length.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. The state is opposed to your application for community supervision and deferred adjudication, and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor, that is our understanding.
State?
Yes, Your Honor, that is our understanding.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
Not to my knowledge, Your Honor, but I'm not the court-appointed lawyer who was here before me, but my understanding in reviewing the file, there are none.
Thank you. And then, Mr. Martinez, to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
The state would offer State's Exhibit 1 and all attachments.
No objection.
All right, State, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We can go off the record. So a PSI takes about 8 to 12 weeks. So we can reset this for 8 to 12 weeks for a PSI and TAP evaluation, or if you would like, I can have this recalled back in a shorter time, and you can bring whatever witnesses you want to bring. And I do ask that the state bring the criminal history.
Your Honor, I think we can probably come back sooner with a couple of witnesses. My client has been recently released from a prison sentence on a revoked probation. He has taken steps, has found meaningful employment, which is difficult for a felon. He has already made arrangements with the state of Texas to get his driver's license reinstated, and has an appointment for that to be done on August 28th. Once that is done, his employment will become full-time and permanent. He has also made arrangements so that he will not have any contact, and this was before this arrangement today. As soon as he got out, he made arrangements so he would not have contact with the mother of his 2 children, and he has been having his mom be the one that picks up and drops off, so that mom doesn't feel threatened in any way. So my client is taking significant steps to try and get that done, and we can present some testimony on that when we come back a little bit sooner.
All right. So then what we will do is, Ms. Ferguson, if I could have a reset date on this for 3 weeks, and if you want to, or do you want it, if you want it sooner, just let us know.
I'd like it, if we can, Your Honor, that first or second week of September. That way he would have already obtained his license by then.
All right. So it can't be the first week in September because I have a judicial conference. So,
The second week.
all right, Ms. Ferguson, what date?
I can do the 8th.
Yeah, Monday works best. I have a docket I have to call on Tuesdays.
All right. Thank you. Once you sign the reset form, you are excused.
Thank you, Judge. We appreciate your patience.
All right. Thank you.
Sure.
No, there's no PSI. Hi. Oh, come on up. How are you doing? Great. Let me just put this in here.
No, because that's a transaction. No.
Oh, and if you'll have your client come up.
Yes.
Thank you. Who's this? All right. So when can you all get a
So I
evaluation?
was speaking with Vashon, Your Honor, as well as Mr. Hilliard. So good news, bad news is we have a lot of referrals that are popping right now.
Yeah.
So we're full transparency to you in the court. If we have 45 days, I can guarantee done, assessed, staffed, and an answer back to the court. As long as Mr. Haynes gives us everything according to as quickly as he has it, There's open a slot for assessment. We'll fill him in there and we may be able to get back sooner.
All right, so this is what's gonna happen. I'm gonna give you a 45-day reset. That's all you all will have for this. After that, so in 45 days, that's gonna be your plea deadline date on that date as well. So everything should be done by then.
Yes, ma'am.
All right, Ms. Ferguson, I need a 45-day reset, please. All right, September 22nd. Once you sign the reset form, you're excused. All right, thank you. You're welcome.
If we get it done sooner, Your Honor, we'll make sure to let the court know.
Okay, if it's done sooner, just let council know
Okay.
and we'll bring him back sooner.
Thank you so much, ma'am.
All right, thank you. All right. Just give me a moment. All right, Larry Morris. Come forward, sir.
He's got a nicer suit on than I do.
Mr. Morris, thank you for dressing appropriately for court. You always do, though. I really do appreciate that.
You're welcome.
All right, so we're back here today. Where are we on Discovery Council?
Your Honor, we have gotten complete discovery.
All right, state on Larry Morris, I'll need a discovery acknowledgement.
Yes, Judge.
And were you able to get a plea?
Judge,
Sorry, an offer tender?
we got an offer. It involves upfront restitution. And DA has given me 45 days, if that's okay with you, to get that together.
All right, Norma, can you recall this also on September 22nd? All right, so September 22nd is going to be your plea deadline date.
Okay.
Once you sign the reset form, you're excused. And once you sign the acknowledgement of discovery, you'll be excused.
Thanks, Judge.
All right, thank you.
All right, have a good day.
Thank you, you too.
You starting back up this afternoon?
Yes, at 1:30.
I was watching you yesterday.
We'll see the way that it goes. People always think that I know what a case is about. And I said, nobody just gives me anything
You
beforehand.
don't want to know.
No, don't want to know.
Okay.
And in my spare time, I like to read other things.
I stare a lot. If I just stare outside.
Frank Garza. Counselor, is there an application?
No, Your Honor.
All right, probation, there's no application. Court is calling 2025 CR 005952, State versus Frank Garza. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Donald Wilson for Mr. Garza.
And are you Mr. Garza?
I am.
Counsel, have you received all discovery and did you review that with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Counsel, I see in the notes that there was a competency evaluation done.
Yes, Your Honor. It was, and it came back that he is competent, and I agree with that.
All right, and he's already been deemed competent by that court and that judge?
That's correct.
All right, thank you. Mr. Garza, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are not. We are proceeding for the lesser included attempted possession to make this a third-degree felony.
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on the lesser included offense of attempted unlawfully carrying a weapon with a felony conviction as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes, ma'am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of attempted unlawful carrying of a weapon with a felony conviction. They're asking that your punishment be assessed at 2 years in the prison and you to forfeit the firearm. Did you understand that to be the plea?
Ma'am.
Defense?
Yes, it is, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
And did you sign it in both places? I'm sorry?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers State's Exhibit 1 and all attachments, Your Honor.
Okay.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, this case is kind of an unfortunate one. Mr. Garza is a resident of Haven for Hope. He suffers from some mental health issues that have been checked out, and he is, I believe, competent and has been confirmed, but he does have problems related to prior injuries that he's had. And this particular day, this weapon was found downtown under the bridge by some other boy, and Mr. Garza picked it up to try to turn it in. He was literally on the phone with 911 on UTSA property whenever he was spotted with a gun on property, and that's what led to this. We've looked at pursuing this to a trial and all that, but Mr. Garza has been locked up for more than 6 months, and he has elected to take this plea. He was in possession. He is a convicted felon, so it meets the technical, allegations, but that was the reason that Mr. Garza has chosen to move forward with this case.
So a gun was discovered, and he was calling the police to turn it in.
He took it, it was during the church under the bridge. He went to use a phone from one of them, which is on the UTSA property, and was, as I understand it, on the phone when UTSA security saw him and came over. And here we are.
Well, my thing is, technically, is that a violation of the law? Yes. But is it a violation of the spirit of the law? It appears that it is not. So I don't know if there's proof of what he's saying or not. Based upon what I'm reading, it's not what's being said. I don't see it in the police report. So.
And with the nature of the offense and the people around, the witnesses, it's a challenge. That's what the defense is faced with, and that's the reason Mr. Garza has elected to.
And I'm assuming that's the reason why the state is proceeding on the lesser
And
included.
then everything changes. Frank Garza steps up, and suddenly the courtroom is facing a question bigger than any statute. What's the difference between breaking the law and doing the right thing? Garza, a convicted felon, claims he picked up a gun only to turn it in to police. Legally, that's possession, a crime. Spiritually, it's a good deed. Judge Boyd openly wrestles with this contradiction, even calling it out. That's not what this law was meant for. This is rare, folks. Judges don't usually tip their hand like this, But here, she lets the audience, and you, see the law bend under the weight of fairness.
On the lesser included.
As well as the minimum.
All right. Then the court will find you guilty of the lesser included offense. The court. All right, so here's my thing. We can go off the record. I understand why the state would proceed on the lesser included offense, and I may be overstepping my bounds here. But if what is being said is true, this just doesn't seem just to the court. I mean, if somebody finds a gun and they're picking it up and on the phone to call the police to say, hey, I found a gun, come and pick it up. Legally, is it possession? But this is not what this law is meant for. Am I wrong? And I understand state why you're reducing it, but do we have any proof of this? I'm telling you all, if there's proof of what he's saying, that he was on the phone, and it appears that there was the gun didn't have any, wasn't loaded or anything.
Your Honor, you do speak to a good point. If there is proof, there has been requests for things that have been alluded in the police report, things that would have corroborated. The state has not been able to receive those things. There have been discussion with defense. The state understands if it came to he said, we understand and believe the report. Things have been requested that we don't have. And
who would have these things?
We've requested specifically without, jumping around the 911. We do not have that. We cannot corroborate.
So where's the 911? Does the 911 not exist?
It's been requested and I haven't gotten word back. Now, we believe with the reports, we have the elements.
Yes.
Yes.
No, I mean, you do have the elements, and you actually have the elements for unlawfully carrying a weapon with a felony conviction, because he has a felony conviction. He was carrying a weapon. So I can sentence him now, or if you want to wait, I can not sentence him today, and they can see about the 911 call.
And Judge, I'll talk to Mr. Garza. This case was set for a couple of weeks from now. Mr. Garza has asked me to push it up to move the case.
So, Mr. Garza, do you understand what's going on?
Just a little bit.
All right. So here's the thing. You're not allowed to possess any weapons if you have a felony conviction. And then there's some things, if you have a family violence, you're not an affirmative finding of family violence, you're not allowed to possess any weapons either. And that's what this law is for, right? And so from reading the police report, you're guilty, right? Because you had a weapon. But if you found a weapon, you picked it up, and you were calling the police to say, hey, I found this weapon, could somebody come and pick it up? To the court, that's not what this law was meant for, because it's more danger to have a weapon just laying around where a child could pick it up or somebody else could pick it up than you're picking it up and calling the police and saying, hey, I found this weapon. And what I'm reading in the police report is that the officer comes up to him and he's like, yes, I do have this weapon, and yes, you may search my backpack and everything. So you can discuss it with your attorney if you want. We can recall it back in 2 weeks. Here's the thing. If it turns out that they can't get the 911 call and you still want to go forward with the 2 years, you'll have the 2 years and you'll get credit. So if we come back in 2 weeks and you end up getting 2 years, guess what? You're still going to get credit for the time that you were waiting for those 2 weeks. It's just you'll be at the Bexar County Jail and not at the prison. It's completely up to you. But for the court, I don't think, and I could be wrong. If I'm wrong, somebody correct me. I don't think that's the spirit of that law. So.
Judge, I'm in agreement with you. It's up to Mr. Garza.
Okay, so can you explain that a little better to me?
All right. So the state has offered you 2 years.
Okay.
I will follow that 2 years if the state if they go and they're not able to get the 911 call because they say they've been trying to get the 911 call, if they are unable to get the 911 call, you'll still have the 2 years. So your waiting 2 weeks is not going to change your position as far as the agreement that's been worked out by your attorney.
We'll be there. We'll be back in a minute.
Or whatever whatever the court says.
I mean, if I have no other choice, but yeah, I mean.
No, I mean, you have choices. These are your choices. I can sentence you to 2 years today, or we can see if the state can find if the state receives, I don't want to say fine, if the state receives the 911 call, then if the state receives the 911 call, they may decide to do something different than what they're doing now, which may be in your favor. But at the end of the day, worst case scenario, you're sentenced to 2 years. You want to discuss it with him in the box and then just let me know? All right, thank you. David Jarrett Castro?
Coach Judge.
Yes. Hey,
Good
okay.
morning, Judge.
Good morning. Where's your client?
He's here, Judge.
Oh, come forward, please. Odyssey is moving slow. All right, so outstanding discovery. Where are we on that?
The prosecutor has asked for the record. We're missing some CPS records. And
I'm sorry, you say CPS records?
CPS records, Judge.
Okay, why isn't that?
Judge, it was late. They got discovery. It mentioned CPS records. I asked for the CPS records. There's a rush on it. I've seen her emails.
Okay.
And then there might be, but I can't tell you for sure. There's a mention in one of the body worn microphones that there's a conversation between the complainant and a female officer. I cannot find that conversation. I'm going to get that section of the transcript and send it to the prosecutor so she knows exactly what I'm looking for.
Okay.
In that transcript, they mention conversations, notations that I have not been able to find in the IDR. They say, I see it's noted here, that, and then they go to explain the notations.
All right, conversations between
officers.
Okay.
The only other place besides the IDR, and I've been out of the game for a while, that I know officers would put down notes to each other is the mobile data terminal notes. So I'm going to also, just in case, ask for the mobile data terminal notes for this case.
All right.
Because I don't see that, I don't see those notes entered into the IDR, which is also a normal place that officers communicate back and forth with each other.
All right. So Ms. Ferguson, this is going to be everybody's final discovery because we've been doing discovery since February. 45 days. That's it. State on that date, you'll also need to be prepared to tender an offer.
Yes, Your Honor.
All right. What date, Ms. Ferguson?
That should be fine, Judge.
Okay. All right. Is there anything else?
No, Judge.
All right. Thank you for dressing appropriately for court. Have a seat. Your attorney will bring the reset form to you.
May I be excused for this,
Yes.
Judge? Thank you. Your Honor.
Thank you, Judge.
Thank you. All right.
Garza agrees to come back in 2 weeks.
All right. Norma, can I get a reset for 2 weeks for Mr. Garza?
Give me the 21st.
Okay.
Thank you, Your Honor.
All right. And you said August 21st?
Yes.
All right. Thank you.
Martha?
Oh, no, go ahead. Oh, I'm sorry. Wait a minute. What did you say? Yeah, it may be back there. If not, let me know. Christopher Scott Stanton. Yes.
Yeah.
All right. And what is happening with this case?
We have a plea. I think we turned in paperwork, so we have an agreement.
All right. Could I have a file stamp for a plea, please? Thank you. Thank you. Court is calling 2025 CR 004713, State versus Christopher Scott Stanton. Could I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Lauren Lupton for Mr. Stanton.
And are you Mr. Stanton?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Counsel, are there any applications?
No, Your Honor.
All right, Mr. Stanton, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Stanton, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 7 months in the state jail facility. There's to be no contact with the complainant. I'm sorry, it's 7 months in the Bear County
Thank you.
Jail
Sorry.
under 1244. There's to be no contact with the complainant. The state will take in consideration 2025 PF 27168, 2025 PF 27169. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is our understanding, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, any evidence?
State offers States Exhibit 1 and all attachments, Your Honor.
No objection.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same.
Yes, ma'am.
All right, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, we just asked the court to follow the agreement.
All right, do you have any children?
I do.
What are their ages?
I have a 3-year-old, and that's just it.
All right, and are you in the 3-year-old's life?
No, no, ma'am.
All right. Court is going to sentence you to 7 months in the Bear County Jail under 1244. Taking consideration 2025 PF 27168, 2025 PF 27169. There's to be no contact with Mariela, Maryela Hernandez, Crystal with a K, Yvette Garza, Gage Hartz, Harts, and there's to be no contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, you have issues. And if you don't take care of those issues, you're going to end up in somebody's jail. I read the police report, so there are drugs involved. If you don't get that handled, what's going to end up happening is you're either going to end up in prison, in jail, or either somebody's going to be identifying your body. When you're released from custody, if you can't find a place to help you with your drug problem, and I'm still here, you come back here, I'll pick up the phone and call to try to get you in a sober house, okay? All right, good luck to you, sir.
Thank you, Judge.
Thank you. All right, Matthew Dotson. Hello.
Hey, I'm back, Your Honor. This is off docket.
Yes.
So my client is noticeably absent due to the warrant that he has.
Okay.
I've been conferring with the state. He's got the MTR warrant.
Mhm.
The MTR is for failure to drug test or it's drug related.
Mhm.
He was ordered to safety. He did not go because his mother took a turn for the worse.
Mhm.
And he can't see her or do rehab on his own, which he has just completed now. He's in sober living. Long story short, what we're asking this court to do is based on, and the mother has since passed now too. Her services are coming up and he is having dental surgery. He has no top teeth. He needs to get that dental surgery that's been in the works for months. We're asking this court to please recall the warrant until a date certain. In a few weeks after he is able to get that procedure and after he is able to lay his mother to rest.
All right, he will need to come in and the court will consider it. But I don't recall warrants if the person is not before me.
But not before even his partner is here if you'd like to inquire of him. But if that's your principle and that's your
Yes.
policy, then we will honor that.
Yes, and as soon as he comes in, today is Thursday, we're in trial tomorrow. So if he wants to come in tomorrow, he can come in.
Okay.
Or either, probably this afternoon is not a good time for the court because we're in trial.
If he were to come in, is the court inclined to, is this something that you may entertain?
Yes, I always keep an open mind.
We don't want him to miss that.
Well, I always tell people, bring documentation.
And we have that documentation,
All right.
but you need him and the documentation. is
Yes.
my understanding. Yes, ma'am. All right.
Yes.
Thank you, Your Honor.
All right, you're welcome. Oh, and is this because there's a motion to revoke?
Yes, Your Honor.
Okay, all right, yeah. He'll need to come in and we'll see where we are. But I always keep an open mind.
Yes, Your Honor. Thank you.
You're welcome. Dennis Johnson. Hello. Good morning. How's it going?
Pretty well.
You know, people always say, oh, it's good seeing you. And then people always say, well, it's great to be seen.
I like to be unseen.
Yeah. All right. So where we're on this case with discovery, what's going on?
Judge, I believe most of this discovery is uploaded on Veripic. I don't know, Mr. Cox, I think maybe just found out today that it is accessible, but I didn't know. I told him just today that I believe there's several surveillance videos that are uploaded. So I didn't tell him this, but maybe if he wants to bring a hard drive, we can get it downloaded for him.
And if I may, Judge, I saw this morning or late last night, I did get something from discovery on a portal from in this case. I haven't had a chance to open it yet.
All right, Ms. Ferguson, if I could have a 30-day reset for discovery. All right, September 9th.
That's fine.
But I'm shocked that you're representing him because of the whole Celtics thing.
Well,
and we have DJ before us.
There are some exceptions to my rules, like Celtics.
Oh, there
are some exceptions.
You know, Parrish was from Freeport.
I didn't know that.
Yes, he went to Centenary College.
He liked to smoke like weed, didn't he?
No, how dare you put that on the great state of Louisiana? Don't even, you know what? Do I need to bring up what happened with Miami when Jerry Jones was there? Because we can take it there.
We don't want to go there.
Do we want to go there? In Texas, you're not immune. I can take it to SMU And while y'all got the death penalty, we can go there.
What's
They
funny,
were just before the NIL. They were the front runners.
That would all be legal.
Well, you know, it was so funny because if you watch the documentary on SMU,
Oh, yeah.
oh, it was just so blatant.
Mhm.
Oh, what, you need a home? Yeah, here's your mansion for you and your family. Here's some cash. You can just take it in the bank and go.
But they start the private, so we owe a lot of gratitude to. Because but for SMU, we wouldn't have the portal and all these things.
Look at Florida giving gratitude to a Texas school.
So SMU ruined it's college football.
All right, thank you so much for dressing appropriately for court.
Is this your Farida?
Yes,
Okay.
that is the person who's supposed to be paying attention to what's going on. Oh, no problem. All right, who's here on, let me see, Juan Martinez?
Morning, Your Honor.
Good morning. Hello, Mr. Martinez.
Hello, ma'am.
All right, counsel, what's going on with this case? There was a file missing. Has the file been found?
No, Judge. We were last here on 7 July. On 6 July, I filed a letter notice of discovery requesting some files from the state. Veripic has not had a file loaded into it on this case since January the 14th of 2025. So my letter request has not been complied with to date. It involves a alleged co-conspirator and his file that was charged under a different cause number. But they're
Well, counsel, let me tell you, this is what I'm going to do. And then after this date, I will entertain whatever motions you wish to provide to the court. So state, it seems like you're all going to have to recreate a file.
The way the state is understanding is there's a co-defendant, Westbrook, who was on our if not most recent, last trial docket date. State believes that defense is asking for that entire file of discovery.
Is that the file you're looking for? So you have the discovery for this file?
I have the discovery for my client, but there's an undercover investigation involving Westbrook that I need to have in order to figure out what's going on here.
All right. And state,
The state has asked defense to bring a hard drive, and we believe that
tomorrow
we can legally, provide this discovery that is related, but also pertinent to another defendant that isn't this one. So I wanted to make sure everything was good in providing this. We are anticipating this hard drive and should be able to.
And how much time are you asking for?
It's voluminous, but not entirely voluminous. We would ask for at least 2-3 weeks.
All right, Ms. Ferguson, if you recall this in 30 days for the defense, that'll give you a chance to look over the discovery.
Judge, it would. My client has been in custody here for quite a while now. I'd like to ask him to come back next Friday. Not this Friday, but next Friday for that discovery.
I have notified defense that there should be a new prosecutor in my spot at this time. I will try to get her up to speed as quickly as possible. But in getting this hard drive, we would go to IT, ask for them to put everything on it. It's hard to determine exactly when we would be able to accomplish this.
All right, Norma.
May I address the court, Your Honor?
Yes.
Judge, this makes the third principal prosecutor on Mr. Martinez's case. Andrew, and then Duffy, and now Lauren.
Well, what I'm going to tell you, counsel, is I'm going to give them this date, and there will be no further dates for them to give you the information that you need that will impact his bond.
Thank you, Your Honor.
So we're going to come back on August 28th.
Judge, I will get the hard drive to Duffy tomorrow.
Okay.
And I thank the court for its time.
All right. Thank you.
Okay. May we be excused?
Yes. Jerry McGee. Hello, Mr. McGee. So is this for a motion to revoke?
It is, Judge. What we were set for recently, he had 4 new cases. It was reset for a global offer. I spoke with Mr. Pitlock this morning. He just provided that offer.
Okay.
I wanted to know if we can have a short reset and come back either Tuesday or Wednesday of next week.
I can bring you back Tuesday of next week.
Tuesday works, Judge.
Yes. All right, Ms. Ferguson, can you recall this for August 12th? All right, is there anything else?
Thanks, Judge.
Thank you. Thank you. All right, who is here on Joe Maria Ramos?
Hi. And Steve Spears covering for Andrea Crespo.
Hello.
Judge.
Hi, how's it going?
It's been a busy
You're running
week.
everywhere.
He's covering for his like whole division.
Yeah.
They're all
Oh,
their
man.
contracts.
All right, so I'm sorry, I'm just pulling this up. Odyssey went down on me. All right, so the competency,
All that is back.
okay,
We've got an offer from Andrea Crespo this morning. And Steve shared that with me. We're gonna reject it at this time and ask for a jury trial.
okay. All right, how long do y'all expect the trial to last?
4 days.
All right, Ms. Ferguson?
Can we get a date, Your Honor? Can I respectfully request a date into December? Is that too late for the
Oh,
court?
just speak with, I
Okay.
was gonna tell you, I'll confer with Ms. Ferguson on a jury trial date.
Okay.
All right,
Is it okay if it's that far out after I leave?
yes,
Okay, thank you.
sure. I understand the reasoning.
Thank you, Judge.
You're welcome. And just come back and let me know the date.
Of course.
Yes, just have a seat. She's gonna bring the form to you. And thank you so much for dressing appropriately for court.
Thank you.
Rodriguez. Signature.
All right, December 11th.
Thanks, Steve.
Thank you.
The kids.
Okay.
I'm unsure if withdraw what is the appropriate remedy,
Okay.
but we can confirm he is deceased.
All right, thank you. All right, Joe Rodriguez. Well, Mr. Rodriguez, come down.
Morning,
Well,
Judge.
Hi, how's it going today?
Well, how are you?
Oh, I cannot complain. You know, birds are chirping. Although last night, oh my gosh, you know, my grandmother would always say that when they're doing that, they're gossiping. They had a lot to tell. Last night, I'm like, please let me sleep. Moms, get your babies inside. Why are they outside? Or who knows, maybe it's the parents, somebody else is watching the children and they got the day out.
Parents not out.
Yeah. All right, so what is happening with this case?
So it looks like we have the discovery all uploaded, Judge, and
Okay.
I don't know if this is the first setting or the second setting.
I believe it's first.
Yeah, it's the first. So all the discovery is uploaded?
All that they have so far. There's still some outstanding ballistics, I believe, some ballistic reports and things like that nature that aren't back yet.
That should be correct, and possibly GSR and also firearms.
All right, Miss Ferguson, I need a 45-day reset for discovery. Is that good?
Sure.
All right, we'll bring you back on September 22nd to make sure that your attorney has the discovery. And on that date, guys, if there's something that's missing, if you could just let me know what is missing so I can put it in the system.
Yes.
All right, thank you.
You're
welcome.
Well, you know, they just gave me a video yesterday they've never given me before. I kid you, I'm not kidding. I got a video on RC Curtis that nobody's ever given me.
Oh, no.
I'm not making this up. Are they filming them? Are they filming them right now?
Did we not? Did we not?
Apparently they got it in November and just somehow forgot to give it to me.
This hearing wasn't just about rulings. It was about humanity colliding with the cold letter of the law. From Thomas admitting his crimes were stupid, to Garza's heartbreaking gray area, to Stanton facing a blunt reality check about drugs and death, Judge Boyd didn't just deliver sentences. She delivered warnings, lessons, and even flashes of compassion. And that's why this courtroom hits so hard. It's not just about justice. It's about the thin line between redemption and ruin. If this case stunned you like it did us, smash that like button, drop your verdict in the comments, and subscribe for more breakdowns every week. Court is adjourned.